Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to UCAN session number 2, where we are discussing polity-based current affairs. What is the period that we shall be covering today? 8th of November to 26th November. If you want the PDF of this lecture, that shall be made available on my Telegram channel. The link to join that channel is provided in the video description. Number 1. Number 2, if you are benefiting from these UCAN sessions and if you want us to continue providing these UCAN sessions freely on YouTube, do let me know in the comment section and also encourage us by pressing the like button and subscribe to our channel if you haven't yet. So if you want us to continue providing UCAN sessions free on YouTube in December as well, do let me know in the comment section what are the topics that we shall be discussing today. 8 in total. We will understand the implication of the AMU judgment. We will look at what is happening in Manipur. We will also look at Armed Forces Special Powers Act, which has been reimposed in Manipur. We will look at the Supreme Court ruling on the bulldozer action or bulldozer Raj or bulldozer justice. These are the terms that you must have frequently encountered. We will look at the consensus document, a beautiful article written in the Indian Express. We will look at the violence that witnessed at Sambhal in Uttar Pradesh and what is the implication of that. We will look at the Preamble Case. This petition was dismissed by the Supreme Court. Remember the case name, Balram Singh versus Union of India, famously known as the Preamble Case. Subramaniam Swamy was also one of the petitioners. And towards the end, we will look at some data point which can be handy for your mains answer writing, because there is a report which says Municipal Corporations tax revenue share has risen in the recent years. Shall we start? Let's get started and let's look at topic number 1, the AMU case. Now listen to me carefully. A 7-judge bench of the Supreme Court ruled and listed down criteria that needs to be followed by a different bench of the Supreme Court to decide whether Aligarh Muslim University is a minority educational institute. So one thing you have to be absolutely clear here is that Supreme Court has not decided that AMU is a minority educational institution. The 7-judge bench has only listed down the criteria on the basis of which an institution can be declared as a minority educational institution. Whether Aligarh Muslim University is a minority educational institution or not, that is for a different bench of the Supreme Court to decide. When we look at Constitution, under Article 30 of the Constitution, it says all minorities, and whether these minorities are based on religion or language. Although Constitution does not define this term minorities, but Article 30 says all minorities, whether based on religion or language, they have a fundamental right. And what is that fundamental right? These minorities, whether based on language or religion, they have a fundamental right to establish, manage, and administer what? Educational institutions of their choice. And such minority educational institutions, they have a lot of freedom when it comes to recruiting, whether teaching staff or non-teaching staff. They have a lot of freedom when it comes to setting up of the syllabus. They have a lot of freedom when it comes to admissions as well. But more importantly, if we look at these minority educational institutions, reservation policy does not extend to these minority educational institutions, which means you would know that there is reservation in educational institutions for SCs, STs, OBCs, and economically backward sections of the society, economically weaker sections of the society. This reservation does not extend to a minority educational institution. That's number one. Number two, these minority educational institutions, they can also reserve up to 50% of their seats for the members of their own community. That's number two. Number three, when it comes to funds, the state, which is secular, when the state is funding some educational institutions, Constitution says under Article 30 that the state shall not discriminate in granting funds to educational institutions just because that particular educational institution is a minority educational institution, which means even the minority educational institutions, they can get funding from the state, which is secular. Long story short, Article 30, which is applicable only to the citizens. You would know that there are fundamental rights which are exclusively available to the citizens of India. For example, Article 15, 16, 19, 29, and 30. Article 30, it gives a fundamental right to all those minorities, whether based on religion or language, that you can establish, manage, and administer educational institutions of your choice. And once you have established these educational institutions, for whatever reason, whether you want to preserve your language, whether you want to serve your community, the state shall not discriminate in granting funds. State can fund minority educational institutions as well. And when it comes to the reservation policy, that does not extend to minority educational institutions. And these minority educational institutions, they can also reserve up to 50% of their seats for the members belonging to their own community. That's the reason why there are lots of communities in India which have been for a long time demanding a minority status. Why? Because if this community is declared as a minority, it will be then eligible, it will then have a fundamental right to establish an educational institution and then reserve seats in that educational institution for the members of their own community. For example, the Lingayats of Karnataka, they have been requesting for a minority status for a long time. And constitutional experts argue that whenever there is a demand from a particular section of the society asking that this community be declared as a minority, their principal objective is that they want to be declared as a minority so that they can establish, manage, and administer educational institutions of their choice. That's Article 30 of the Constitution. When it comes to Aligarh Muslim University, the predecessor of this Aligarh Muslim University was the Mohammedan Anglo-Oriental College, which was established in 1870s by Sir Syed Ahmad Khan. What was his objective? His objective was to ensure in some way that Muslims come closer to the British Empire. Why? Revolt of 1857. A massive revolt broke out in the northern and central part of India and nearly swept away the British rule. In this revolt of 1857, Muslims and Hindus together, they participated in massive numbers. But then this revolt had to be crushed as well. And the British government initially targeted the Muslims because that was their policy of divide and rule. Initially, they targeted the Muslims, and over a period of time, they appeased the Muslim community because they wanted to divide and rule this country. And Sir Syed Ahmad Khan felt that Muslims who were the victims of the British onslaught after the revolt of 1857, these Muslims should come closer to the British Empire so that their interests are better served under the British Empire. Plus, he also wanted to reform his community. He wanted his community not just to study the Quran or the Hadith or the Islamic literature, but he wanted them to also study science, mathematics, humanities, philosophy, so on and so forth. So he wanted to modernize his own community. So what was the intention? The intention was to serve the Muslim community. Long story short, this Mohammedan Anglo-Oriental College which was started by Sir Syed Ahmad Khan, over a period of time became the Aligarh Muslim University. And this Aligarh Muslim University was established by the legislature, by the state legislature before the independence of India. But then over a period of time, this Aligarh Muslim University was also given the status of National Institute of Eminence. For example, if you look at the Constitution, look at Schedule 7 of the Constitution, look at Union List of Schedule 7. In that you will see entry 63. In that you will see mention of universities such as Banaras Hindu University, Aligarh Muslim University, Delhi University. These are the institutions of national importance. Now the question before the court was whether Aligarh Muslim University, whose predecessor is the Mohammedan Anglo-Oriental College, but this Aligarh Muslim University, which is now what? A national institution, which is now a central university, which is now managed by not the Muslim community themselves, whether it can claim the benefit of a minority educational institution. For that, we have to go back in time and we have to look at the history. The year was 1965. As I told you, this Aligarh Muslim University, it was established by the act of the legislature. The year was 1920. Aligarh Muslim University Act of 1920. Initially, who had the responsibility of governing this university, of managing this university, of administering this university? That power was given to the university court. And this university court was dominated by the Muslims. And over a period of time, in 1965, the powers of this university court were diluted. This university court, who initially had been administering this university, now this university court was made an advisory body. And this university court, which had the Muslims as the members of this university court to manage this institution, now in this university court, other members were to be appointed or nominated by the President of India. So the powers of this university court were diluted. The composition was also diluted by adding more nominated members by the president. This amendment to the 1920 law, which happened in 1965, it was challenged in the court. Aziz Basha versus Union of India. Why? Because the petitioners argued that these amendments would violate Article 30 of the Constitution. Because all minorities, whether based on language or religion, they have the fundamental right to establish, manage, and administer educational institutions of their choice. Now, if this university court has become an advisory body, and this university court will also have nominated members of the president, then Muslim community themselves cannot administer Aligarh Muslim University. The Supreme Court upheld this amendment, saying there is no problem with this amendment. Why? Because Aligarh Muslim University is not a minority educational institution. Why? Because it has been established by the central legislature. It is being administered by the government of India. So Article 30 will protect only those educational institutions which come into existence by the minority themselves, which is being administered by the minority themselves, which is being governed by the minority themselves. Since Aligarh Muslim University has been brought into existence by the act passed by the legislature, by the government of India, it does not enjoy the protection under Article 30 of the Constitution. This was Aziz Basha versus Union of India. The year was 1967. But then the year was 1981. The legislature amended this Aligarh Muslim University Act of 1920. How? Saying that this Aligarh Muslim University is a minority educational institution because it has been established for advancing the requirements of the minority community, which is the Muslims. Because in Aziz Basha case in 1967, Supreme Court ruled AMU is not a minority educational institution. Now in 1981, the law has been amended to confer minority educational status on AMU, which was denied by the Supreme Court. And then the year was 2005, when the Aligarh Muslim University decided that we will reserve seats for Muslims in postgraduate medical courses. Because if you are a minority educational institution, you can reserve up to 50% of the seats for the members of your own community as well. This amendment of 1981, which conferred minority educational status on AMU, then this 2005 notification of Aligarh Muslim University, wherein they wanted to provide reservation to Muslim students in PG medical courses, both these were challenged in the Allahabad High Court. And Allahabad High Court in the year 2006 said both this amendment of 1981 and the notification issued by the university in 2005, it is unconstitutional, invalid. Why? Because the court, the Allahabad High Court, relied on the 1967 Aziz Basha judgment, because in that judgment, the court had said that AMU is not a minority educational institution. Then, as is the norm, if you are not getting a favorable judgment from a high court, you file an appeal before the Supreme Court. And now Supreme Court had to hear this matter on an appeal. The year was 2019, when the Supreme Court referred this matter to a larger 7-judge bench to decide some issues. And now this 7-judge bench gave the verdict this month. And this verdict was a 4:3 split. 4:3 split. 4 judges were in favor, 3 were against. And what was this judgment? Again, I will reiterate. The 7 judges did not declare or rule that AMU is a minority educational institution. The Supreme Court only clarified a test. That these are the tests that we need to follow. This is the test which has been prescribed. And if you fulfill these conditions, then this educational institution can be declared as a minority educational institution. Otherwise, no. That means this 4:3 judgment, which prescribes a test. Now, this test will have to be followed by another bench of the Supreme Court to decide whether AMU is a minority educational institution or not. And what is this test? The Supreme Court clarified that what is the purpose of establishing a minority educational institution? If a minority is establishing an educational institution, its purpose cannot only be that this minority community wants to preserve and conserve its language, its culture, its script. That may be one of the most important reasons that you're establishing this educational institution if you are a linguistic minority, because you wanted to preserve your language, your script, your culture. But that may not be the only reason. That may be one of the most important reasons, but that cannot be the only purpose why you are establishing this institute. So if we have to look at an institute to see whether it's a minority or not a minority institution, we can't solely rely on the fact that whether this institution is there to conserve, preserve the language, script, and culture of that community. It may be imparting education in literature as well, in science as well, in humanities as well, in medicine as well, in engineering as well, in law as well. So this educational institution which you are establishing, or which is established by a minority community, whether based on language or religion, the purpose of this educational institution may be to preserve the language, script, and culture, but that may not also be the only reason. The reason can be something else as well. We want to teach humanities, law, medicine as well. And just because a minority educational institution is admitting students from a different community as well, that does not mean that this institution will lose its minority character. So if there is a university which has been established by the minorities, but they are also admitting non-minority students as well, that does not mean that this minority educational institution, which is admitting non-minority students, will lose its character of a minority educational institution. Third, secular education can also be imparted in these minority educational institutions. English literature may be taught, humanities may be taught, philosophy may be taught, Voltaire may be taught, but that will not impact the minority character of that institution. But listen to me carefully. If this minority educational institution is receiving aid from the state, and remember the state is secular, then this minority educational institution cannot force religious instruction on their students. What does that mean? Listen to me carefully. There is something called religious education and there is something called religious instruction. Do universities not provide courses or degrees when it comes to the studies related to a particular religion? They do. There are courses which provide Islamic history or Buddhist history or Hindu philosophy. That's completely fine. That is religious education. But when it comes to religious instruction, for example, there is a Christian missionary school, and every morning at the time of the prayer, the morning prayers, are you forced to also participate in the morning prayer? You may be forced because it's a minority educational institution and it is not receiving funds from the state. But the court has clarified, if this minority educational institution is receiving funds from the state, because the state is secular, it cannot force religious instruction. So participating in the prayers, participating in the rituals of a particular religion, you will not be forced to do that because it is an institution which is receiving aid funds from the state. But if this is an institution which is fully funded by the state, although it's a minority educational institution, but it is fully funded by the state, you cannot even impart religious instruction. Because the state can fund minority educational institutions. But if it is funding, then you cannot force religious instruction. Religious instruction can be optional. But if the state is the only entity through which you are able to sustain your minority educational institution, then you can't even impose religious instruction, teach religious instruction. Now it comes to the test. What is the test that the court has prescribed? And basis this test, the court will determine whether a particular institution is a minority educational institution or not. Court said, number one, we have to trace the origin of the idea. If the idea of an Aligarh Muslim University is traced back to Sir Syed Ahmad Khan and Mohammedan Anglo-Oriental College, then AMU is a minority educational institution. So test number one that the court has prescribed is whether X is a minority institution or not. We will have to trace the origin of this institution. What led to the establishment of this institution? Who was the brain behind the establishment of this institution? The purpose of this institution may have been predominantly that we want to benefit our community, but that cannot be the only purpose. Your purpose may also be to help other communities as well. Other communities gain secular education as well. So first we have to look at who was the brain behind establishing this university. How can we trace the idea of the establishment of this university or a college or an institution? Second, who implemented that idea? Who contributed funds for this institution? How was the land obtained for this institution? Who was instrumental in getting the necessary permissions, because you need permission of the local authorities to establish an institution as well? Who was instrumental in getting all these things implemented on ground? Who was there who handled the construction and infrastructure of this institution? And then the court said, and this is a very important point, when it comes to an institution which was established before the Constitution came into force, just like AMU, if the origin is the Anglo-Oriental College of 1870s, and if it was established in 1920 as Aligarh Muslim University, that means this institution was created, established prior to the commencement of the Constitution, then how can we decide whether this institute is a minority educational institution or not? We have to look at who was administering this institution at the time of the commencement of the Constitution. If the Constitution came into effect on 26 January 1950, at that time, who was administering this institution? Was the administration under the control of the community itself? Or was the control with the government? If the control was with the community themselves, then it is a minority educational institute. The court clarified that whenever a minority, whether based on language or religion, tries to establish an educational institution, this educational institution needs the support of the government, need the support of the state. How? In getting accreditation, in getting recognition. So this institution can be recognized by University Grants Commission. It can be recognized by the Medical Council of India. It can be recognized by the All India Council for Technical Education. That does not mean this institution will lose its character of a minority educational institution just because it has been recognized by the state, which is secular. So these are the tests that need to be performed. Test number one, who was the idea? Who was the brain behind the idea? We have to trace the origin of the idea behind establishing this institution. Then who implemented this idea? Then at the time of the commencement of the Constitution, if this institution was established prior to the commencement of the Constitution, at the time of the commencement of the Constitution, who was administering this institution? Basis this, constitutional experts say that it paves way for this another bench of the Supreme Court to decide and rule in favor of AMU being a minority educational institution. Because you can trace the idea of the establishment of this university to Anglo-Oriental College, to Sir Syed Ahmad Khan, for the betterment of their own community. And at the time of the commencement of the Constitution, it was the University Court which was administering this institution. When it was administering this institution, it was dominated by the Muslims, which means it is a minority educational institution. But that is for a different bench of the Supreme Court to decide. What the 7-judge benches did, what the 7 judges did, they prescribed a test to be followed in determining the character of an institute. That completes our topic number 1. Any questions? Great. Let's look at topic number 2, the preamble case. Remember the case name, if at all it is asked, Balram Singh and others versus Union of India, 2024. A bit of background. Preamble was the last item added to the Constitution. That's something that you would know. Just like any other part of the Constitution, just like any other article of the Constitution, it was thoroughly debated in the Constituent Assembly, then voted upon, and then these articles or these parts became part of the Constitution. Just like that, preamble was also debated, thoroughly discussed and voted upon. In fact, it was the last item to be voted upon, and that's how it became part of the Constitution. And in Keshavananda Bharati case, Supreme Court said preamble is part of the Constitution. But the year was 1976, 42nd Constitutional Amendment Act. The period was emergency. Srimati Indira Gandhi was the Prime Minister. Constitution was amended, preamble was amended, and few words were added. Words such as socialist, which was the other word? Secular. Which was the other word? Integrity. Now listen to me carefully. What does preamble tell us? We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, political, liberty, equality, fraternity, justice. And at the end, it tells us that we have adopted this constitution on 26th November 1949, which is the date of adoption. So this is something that we know. Come to the point. I'm coming to the point. This is very important. Can preamble be amended? Yes, without altering the basic structure. Because in Keshavananda Bharti case, Supreme Court said Parliament has the power to amend any provision of the Constitution, save basic structure, without altering the basic structure. Right or wrong? Right. Can tomorrow Parliament invoke Article 368 to amend preamble and say that we have adopted this Constitution on the 16th of May, 2014? 2014 May, this is when Mr. Modi was sworn in as the Prime Minister of India. This is where Rajdeep Sardesai writes a book, 2014, the year India changed, the election that changed India. This is where a honorable member of the Parliament from Mandi says we got the independence. If Parliament has the power to amend the Constitution, which means to amend the preamble as well, which means if anything can be amended in the preamble, can we also change the date of adoption and say we have adopted this Constitution on the 16th of May, 2014? Subramaniam Swamy and before that Balram Singh approached the court in 2020 and asked the Supreme Court that you please rule that adding these words is unconstitutional. Why? Because these words were amended during the period of emergency. These words were not originally thought of by the members of the Constituent Assembly. You are committing fraud on the Constitution by surreptitiously adding these words into the preamble. This should be declared unconstitutional. That was the petition before the court. One thing that you must keep in mind here, the Supreme Court has declared or not declared that these words, adding these words is not unconstitutional. What has the Supreme Court said? Supreme Court has not looked at this topic, looked at this petition on merits. Supreme Court has dismissed this petition. That's something that you have to be very careful about. The Supreme Court has not ruled that there is no problem in adding these words, socialist, secular, or integrity into the Constitution. The Supreme Court has simply dismissed this petition. What is the difference? If the case has been dismissed, which means this question has not been answered, whether it was rightly done or not. The court has simply dismissed the petition saying there is no merit in your arguments. We are not going to even spend time on hearing this case. The case has been dismissed. The petition has been dismissed. In fact, there is an editorial in today's The Hindu newspaper as well on this topic, but let me briefly summarize it for you. Is it not true that the Constituent Assembly, which drafted the Constitution, did not deliberately use these terms, secular or socialist, in the Constitution? Yes. For example, this term secular. Why did the Constituent Assembly not use this term secular in the preamble? Because the Constituent Assembly thought that there is no need to add this term because the Constitution is secular. The state has been declared as secular. How? Look at Article 14 of the Constitution, which talks about equality before law, equal protection of the laws. Equality before law. Before law, everybody is equal. That means non-discrimination on the grounds of religion. Article 15, which prohibits discrimination on one of the grounds, which is religion. Article 16, which talks about equality of opportunity in public employment. There can be no discrimination when the state is advertising posts, inviting application for jobs. In public employment, there can be no discrimination on one of the grounds, which is religion. Article 25, which gives the freedom for every single individual on the soil of India to profess, practice, and propagate your religion. On top of that, Article 27, which prohibits the state from imposing tax for the promotion of a particular religion. Article 30, which gives rights to religious minorities as well. So Constituent Assembly thought that we don't need to explicitly mention this term secular. Why? Because the constitution that we have laid is secular in its core, in its ideology, because of these provisions. When it comes to socialist, Dr. Ambedkar had his take. He said, we don't want this Constituent Assembly to bind the future generations into a particular economic ideology or philosophy. It is for the future generation to decide what sort of economic policy they want to follow. We should not bind the future generation in telling them that this is the particular economic philosophy that you have to follow. In fact, in the last UCAN session, we discussed one doctrine of Justice V.R. Krishna Iyer, wherein he said that all the property is the communal resource which can be distributed by the state. Because Article 39, Clause B, which is part of the directive principles of the state policy, what does it say? The material resources of a community shall be so distributed so as to subserve the common good. But what is this material resource of a community? Whether this material resource can be private property as well. Justice Krishna Iyer had said, all the property, including the private property, is the property or the resource of a community, material resource of a community. But last month, Supreme Court said, no, this V.R. Krishna Iyer doctrine related to private property is not something that we will follow. It represents the economic philosophy of the past. Now, not all private property is the material resource of a community. Just like that, Dr. Ambedkar had said, we don't want our future generation to be bound by one particular philosophy by one particular economic philosophy. That's why these terms, socialist and secular, they were not added to the preamble. And in fact, the court said, this petition has been filed in 2020. Nearly 44 years after the amendment was made. So this is a mischievous petition, basically. Hence, we are dismissing this petition. And in fact, if 42nd Amendment of the Constitution was made in 1976, what happened in 1978? 44th Constitutional Amendment Act was passed, which tried to nullify all the changes made to the Constitution in 1976. But even the 44th Amendment did not dare to delete these terms, socialist or secular, from the Constitution, from the preamble. That's why this matter has now been settled once and for all. These terms, socialist, secular, integrity, will remain part of the preamble. In fact, the Chief Justice of India, Justice Sanjeev Khanna, said something important. He said, India has developed its own interpretation of secularism. And what is that own interpretation of secularism? State will neither support a particular religion, nor will penalize those who are professing another religion, who are practicing another religion. That's the form of secularism that we have. When it comes to socialism, Indira Gandhi was asked, what is your brand of socialism? She said, we have our own brand of socialism. She was asked, what is your own brand of socialism? She did not elaborate. But later on, the courts have clearly spelled out what does socialism mean in our preamble. And that is something that has been reiterated by the court in this preamble case. Supreme Court has said, we have a principle of economic and social justice, which is in fact one of the objectives of the Constitution mentioned in the preamble. And as part of this objective of economic justice and social justice, the state has to ensure that there should be no citizen who should feel disadvantaged because of his or her economic status or because of his or her social status or social circumstance. That is socialism for us. Our socialism is not the Marxian socialism. Our socialism is rooted in Indian ethos. And if Parliament has the power to amend any provision of the Constitution without altering the basic structure, this power of the Parliament to amend the Constitution would extend to preamble as well, without diluting the basic structure. And in fact, you would know that in 1994, in S.R. Bommai versus Union of India, Supreme Court said that secularism is part of the basic structure of the Constitution. So how do we conclude this topic? Supreme Court has dismissed this petition. So now this matter has been settled once and for all. Preamble case, this is the end of the story. Any questions? Please let me know. If the case was dismissed, then why was the case named? Because somebody had approached the court. So when the court has to dismiss something, it has to have a title. So this petition has been dismissed. Okay. Now let's look at topic number 3, bulldozer action. Bulldozer justice, bulldozer Raj, bulldozer action. These are the terms that you must have encountered in the newspapers over the past many years. What does this term bulldozer action mean? Now listen to me carefully. There is a disturbance in a particular area, primarily a communal disturbance involving 2 communities. Then the administration comes, brings in the bulldozer and destroys or demolishes the property of those who are accused of this communal violence. This is where constitutional expert Gautam Bhatia, he argues that this can be termed as domicide, bulldozer justice. So you are demolishing the houses of those who are accused of committing or resorting to this communal violence. Now listen to me carefully. Who has the power to declare whether you are guilty or innocent? That's the power available with the courts, because there is separation of powers. The idea that there should be a separate institution, separate organ which can define, which can give justice to the people, that's the judiciary. How can executive take it upon itself and declare that these particular accused, they have committed these crimes and we want to punish them by bulldozing their houses and property? This is what we call domicide. This goes against the principles of rule of law. This goes also against the principles of separation of powers. In fact, let's look at it differently. Even if I am part of this communal violence, I've resorted to communal violence, I have been declared guilty by the courts as well. Even then, no authority can ask the municipal authority to demolish my house. Even if I am guilty, even then my property cannot be snatched. My property cannot be demolished. Why? Because that is not part of any law. There is rule of law in India. But the administration says, we are not demolishing the property of these accused just because they are part of the communal violence. We are demolishing the property of those who have constructed it illegally. So these are illegal properties. These are illegal constructions. And it is our right, our duty to clear these illegal constructions. That's what we are doing. So this is not bulldozer justice. This is the law of the land, because we are only clearing out the illegal constructions. Whether you side by the arguments given by the administration or you side with the arguments given by some constitutional experts, we have to then go to the judiciary to tell us what is the impact of this. What is the real situation here? How do we deal with this particular situation? Some constitutional experts say this is similar to state-sponsored violence, wherein, although the victims of bulldozer action are not only from the minority communities, although majority of the instances have been targeting at the minorities, but there have been instances where even people from the majority community who were accused of certain crimes, their houses were demolished. And this is viewed as quick action by the administration to quell this communal violence. And that is what has been supported by the supporters of the administration as well. In fact, that is how the monikers have been used: Bulldozer Baba, Bulldozer Mama, so on and so forth. This has been going on for 3 years, and finally, in September this year, the Supreme Court paused all these bulldozer actions till October 1. But Supreme Court clarified, we are only talking about putting a pause on those bulldozer actions where you resort to bulldozer action only after there is a communal violence in a particular area and you target the houses of the accused in this communal violence. It is this bulldozer action that we want to pause till October 1, because then we will frame guidelines. But if there is an illegal construction, whether this illegal construction is of a mosque or a church or a gurdwara or a temple, we will not stop you. Genuine illegal constructions should be demolished, can be demolished. This pause will not apply to those demolitions which the administration is carrying out to wipe out the illegal constructions. We are only talking about specific bulldozer action when you are resorting to this bulldozer action immediately after the communal violence. In some cases, it takes an extreme form. For example, there was an individual who had rented out his house to another individual, and then that individual's son was accused of communal violence. Administration came, brought in the bulldozer and demolished the house of this individual. So if I am the owner of this house, I have rented this house to somebody, that somebody's son is resorting to a communal violence, accused in communal violence. Why is my property getting destroyed, demolished? Because it is also the case of right to shelter. In this particular house, it's not only the accused who is residing, it is also the family of the accused who may have nothing to do with the violence. And some constitutional experts say that this speaks similar to the kind of justice we saw during the medieval times. During the medieval times, if there is an individual who was found guilty of treason, not only was he hanged, along with him, his family members were also executed. So if you're accused of a crime, if you're accused of a communal violence, bulldozers will come and demolish the house, even if in this house are residing those who have got nothing to do with this violence. The court has finally said enough is enough. There can't be such bulldozer actions. We will lay guidelines. And what are these guidelines? Guidelines number 1, 15-day notice. What is this 15-day notice? If you think that this particular building has been illegally constructed, it is an illegal construction, give 15-day written notice to this owner. Give him details about the construction. Give him reasons why you think that this illegal construction should be bulldozed. 15-day notice, and this should be a written notice. Why? So that there is no scope of backdating. What do we mean by backdating? In some instances, the administration says that just because there was a communal violence, just because you are an accused in this communal violence, just because of that, we are not demolishing your illegally constructed property. Because we had already given you a notice that you should vacate this property because we are demolishing it because it is an illegal construction. But you send this notice only after the communal violence has broken out. And then you backdate it, saying this notice we had printed 10 days ago. It has been delivered only now. The court has said enough is enough. You have to give 15-day written notice to the owner, giving him the reason that this particular area, this particular construction is illegal construction, why it should be demolished. And then there should be a personal hearing. Once this 15-day notice is served on me, if I am the owner of this illegally constructed property, then you have to give me a personal hearing where personally I will tell the administration why you should not demolish this. Why? Because I am the real owner of this property. Why? Because I have the necessary permission to construct this building. But even after that, this personal hearing, you have to record the minutes of the meeting. Everything that I say in my defense, you have to record it. Even after hearing me, if you still order action, bulldozer action, that your property should be demolished, this entire thing should be paused for 15 days. That means after this personal hearing, even if the administration says that your property was illegally constructed, you cannot go ahead and demolish this property till the expiry of 15 days. Why? Because during this 15-day period, I may demolish the part of the construction which is illegally constructed on my own. I may approach the court and ask for a stay. Even if it is not happening, only after 15 days you can demolish my property, and you have to videograph that demolition as well. So what are these guidelines? And all these guidelines, important for you, is that the Supreme Court invoked its plenary power under Article 142 of the Constitution. Under Article 142, Supreme Court can issue any order so as to give complete justice. And using this power, extraordinary power, the Supreme Court issued guidelines that if you are the owner of an alleged illegal construction, the administration has to give you 15-day notice explaining what part of this construction is illegal. Give details about that construction. Then give opportunity for a physical personal hearing. And in that personal hearing, whatever I will say, whatever proofs I will give, you have to record them. Even after that, if you still order demolition, you have to wait for 15 days. Only after 15 days, you can order the demolition. You can go ahead with the demolition. Because during this 15-day period, maybe I will demolish the illegal construction myself. Maybe I will get a stay order from the court. Maybe I can evict some of the precious belongings that I have. And only after that, proper videography should be conducted when the house is being demolished. And if it is found that those officials, they have violated these guidelines and ordered the demolition of the property without following this due process, punishment will be given to those officials in the form of that they will be booked for contempt of court. And if they have ordered illegal demolition, then you have to repair that construction as well. You have to reconstruct that property. And how will we get the money to reconstruct this property? From the salary of these public officials who ordered demolition. This the Supreme Court did by invoking Article 142 of the Constitution. Because the court said, executive cannot replace judiciary in performing its core functions, because it's the job of the judiciary to declare whether you are guilty or innocent. The executive, the administration, the municipality, they cannot decide whether this person is guilty or not and will demolish the property of an individual. Second, the court said something about, very interesting, very important, public trust and transparency. The Supreme Court said public officials must be held accountable for their actions as well, for their inactions as well. How will we see whether this is bulldozer Raj or whether it is the legitimate objective of the authorities to clear the illegal construction? Because this can be a question on your mind. Sir, how can we decide whether something, you are basically binding the hands of the administration? Then by this logic, we cannot clear all the illegal constructed properties in India, because illegal construction is rampant in India, in different parts of the country. How can we put an end to this illegal construction? That means the administration cannot go after these illegally constructed property because they will fear the Supreme Court. The court clarified. Court said, if there are illegal constructions in this particular area, but the administration is pinpointing one house, and this one house belonged to a particular member, belonged to an accused in communal violence. If you're not demolishing other illegal constructions, but you are pointing out only on one illegal construction, which means your objective, your reason, your intention is not to weed out illegal construction, but your intention is to promote this bulldozer Raj. So there has to be public trust, there has to be transparency. And the Supreme Court reiterated, right to shelter is a fundamental right under Article 21. It's a dwelling space, not only for the accused, but also for those who have no interest in that violence, who are not connected to that violence whatsoever. So you can't violate right to shelter. So Article 142 becomes important, right to shelter becomes important, and this judgment has been praised by many who said that this is how it can be better tackled. This is how bulldozer Raj can be effectively tackled. How? Because now public officials will fare. They will not order the demolition of those properties who these properties belong to the accused in criminal cases, because they would know that if tomorrow it is found that this was illegally ordered, then we will have to pay from our own salaries the reconstruction of that property. This is how you can prevent the misuse of bulldozer Raj. And as always, there are those who criticize this judgment, saying, what about instances where this bulldozer justice was done prior to these guidelines issued by the court? What will happen to those illegally ordered demolitions prior to these guidelines which have been framed? There should have been justice for them as well. But be that as it may, this completes our topic, bulldozer action. Any question? Yes, it is 30 days in total, 15 plus 15. Now let's look at topic number 4, Manipur issue. Manipur is boiling for more than a year now. Even then, unfortunately, there is no end to the crisis in Manipur. Our hearts goes to those who have been the victims of this violence in Manipur. Let calm heads prevail. Hopefully, the government should wake up and address this problem in Manipur, because it has the potential of ravaging the state apart. Northeast is too important a territory for us, not just because of its land, but because of its people, because of its culture, because they belong to India. And if one part of the Northeast is burning, or for that matter, any part of India is burning, our hearts should also ache as well. Unfortunately, I think for the first time I became emotional looking at this issue. Otherwise, I keep my emotions under check, but something seriously should be done in Manipur. But be that as it may, let's look at what is the issue in Manipur. Manipur as a state, it was previously a union territory, then it was upgraded to that of a state. Manipur has hills and the valley. If you look at the 60-member Legislative Assembly in Manipur, 40 MLAs are sent from the valley where the standard of living is better, and it is this valley which is dominated by the Métis. When it comes to hills, they send 20 MLAs, and these hills are dominated by the tribes. For example, Kukis. For example, Nagas as well. And it pains to give this information, but it's also important for understanding the larger context. The valley is dominated by the Hindus, and the hills are dominated by the tribes who predominantly belong to the Christian community. And for a long time, there was this conflict between the hills and the valley, between the Métis and the tribes. Some of the Métis have SC status, scheduled caste status. Some have OBC status. But they had a long pending demand that we should also get the ST status. Who are the STs? The tribes, the Kukis, the Nagas. Some steps, some actions were taken by N. Biren Singh government, the BJP government in Manipur. And Mr. Biren Singh is also a Métis. Some steps were taken by Biren Singh which were viewed as anti-tribals. For example, he started some land reclamation policies. What is this land reclamation policies? The government alleged that there is a government land, there is a forest land which has been illegally captured by some people, and we need to evict those illegal occupiers of this government and forest land. Kukis, for example, they thought that this is an assault on us because we are the owners of this land, we are managing this land, and you want to evict us from our own lands because you belong to the Métis community. I don't know who is right and who is wrong. So whenever you read a particular story, please assume that this is not completely true. There may be something else as well, which you and me, we never get to know. Because what we are told in media is what media wants us to know. What you're reading today, what you're viewing today is what they want you to read and hear. What may be the exact situation, we don't know. So I will just go by what some credible newspapers are mentioning. For example, Hindu, for example, Indian Express, for example, some of the newspapers and web portals coming from the Northeast and Manipur. So I will focus on that. I will not focus on the Republic TV or the Z News and Aaj Taks of India. Some land reclamation policies, and this, the Kukis thought that this is an assault on us. You want to basically deprive us of our land, right? Second, N. Biren Singh, he also wanted to attack the drug mafia. He wanted to clear the poppy cultivation in the hilly areas of Manipur. And let's be clear, there is a transnational drug cartel as well. There is an involvement of Myanmar as well in bringing drugs through Manipur route. So N. Biren Singh, he started this policy of land reclamation. He also launched a vehement attack on the drug mafia. And by destroying the crops, the poppy cultivation and other crops, maybe the Kukis felt that you are basically destroying our crops. Your target is not to put an end to drug mafia. Your target is to keep us out of livelihood. To assuage the grievances of the Kukis, N. Biren Singh government also started a campaign called Back to Hills, where he wanted his officials, the government officers, to travel to hills and address the problems of the people who are inhabiting the hills. But the Kukis felt that through this initiative of Back to Hills, you're not trying to assuage our grievances, you're trying to court the friendship of the Nagas. So you're still against Kukis. So this was brimming, this conflict between the Kukis and the Métis was brimming in Manipur. Then came the final trigger. Then came the immediate cause. And the immediate cause was the order given by the Manipur High Court. As I told you before, it was a long pending demand of the Métis that we should be given, we should be granted ST status. And Manipur High Court, hearing this petition filed by some Métis that we should be granted ST status, Manipur High Court ordered the state government that you should expeditiously consider granting ST status to Métis. And expeditiously means preferably within the 1 month of the receipt of this order. So within 1 month of this Manipur High Court order of granting ST status to Métis, the state government should consider granting ST status to Métis. This was the immediate trigger where the Cookies thought that now this is a final attack on us. Now we have to compete with Métis when it comes to government jobs. Now Métis will claim the hills as well. So this domination, extra domination, it played a role. There were massive protests, then riots, and then Cookies were also killed. Métis were also killed. Young men, women, children. State is on boil. Luckily, this Manipur High Court order was later revoked, was withdrawn by Manipur High Court. Why? Because the Supreme Court castigated Manipur High Court. Why? Because there is a judgment. Milind versus State of Maharashtra. Way back in the year 2000, where a 5-judge bench, a constitution bench of the Supreme Court ruled and declared that no state government, no tribunal, no court has the power to grant ST status to anybody or SC status to anybody. Who has that power? For that, we have a procedure. Parliament will have to pass a bill if you want to add somebody in this ST list, a community in this ST list, or remove, or adds a caste in the SC group, SC list, or remove. For that, bill has to be passed by the Parliament. And after the passage of this bill by the Parliament, it is the President of India who will notify what? Constitution, SC and ST order of 1950. So it is this Constitution, SC/ST order of 1950, which is to be notified by the President, where the President has the power, which means the central government has the power to add something to this list, to remove something from this list. So how can Manipur High Court ask the state government to expeditiously, within 1 month of the receipt of this order, consider granting ST status to Métis? Because that's not the power of the court. That's not power of the state government. That has been clarified by the 5 judges of the Supreme Court in Milind versus State of Maharashtra. That's the power available with the President when the President will notify this order after a bill has been passed by the Indian Parliament. Even after that, we saw the violence continued, and finally, Article 355 was invoked. What is Article 355? It's a duty on the union. What is the duty of the union? That you have to ensure, you have to protect every state from external aggression, from internal disturbance as well. And you have to ensure that the governance in every state is being carried out according to the provisions of the Constitution. So if in Manipur there is internal disturbance, Article 355 was invoked for Manipur. Now central government will have more control over the security situation in Manipur. There are 2 things that are being demanded now. 2 or 3 things which are being demanded now. 1, the resignation of the Chief Minister, because he has miserably failed to control the law and order, to ensure law and order. And it seems that that should happen. The Chief Minister should resign. Second, the demand is for the imposition of Article 356. So this is a fit case for Article 356. Why is it not being imposed? Maybe because the state government and the central government controlled by the same political party. If it was a government ruled by the opposition, 110%, 1059%, the president's rule would have been invoked, would have been imposed in Manipur. But now the Cookies, what they are demanding split of Manipur. And they want these hills to be converted into a union territory. And this union territory should have also a legislature, just like we have in Delhi, just like we have in Puducherry, just like we have in Jammu and Kashmir. So these are a couple of demands. But whatever it is, let peace prevail in Manipur. For that, what you need to understand, what is the background of this crisis in Manipur? You need to understand how High Court cannot grant ST status to anybody. For that, you need to understand this millionth judgment. You need to understand Constitution Order of 1950. You need to understand how some castes or tribes can be added or removed from the central list of SCs and STs. For that, you need to understand Article 355. Clear? That completes our topic number 4. Any questions? Okay. Now in Manipur, again, Armed Forces Special Powers Act has been imposed. What is this Armed Forces Special Powers Act? Initially, there was a problem in Assam and Manipur as well. Manipur then was a union territory. In Assam, we saw the problem because of the Nagas, because they were demanding a separate country. Nagaland then was part of Assam. And this is where Armed Forces, Assam and Manipur Special Powers Ordinance was promulgated by the President of India in 1958. And after that, this ordinance was replaced by a bill, AFSPA. This act was promulgated. But what is this Armed Forces Special Powers Act? Listen to me carefully. I think I've discussed this a couple of times before, but if you're attending this session for the first time, my session for the first time, let me briefly tell it. Let me briefly explain. Police or the paramilitary troops, they have the responsibility of ensuring law and order in a particular state. Clear? Predominantly police, but to assist police, there can be central paramilitary troops as well, CRPF, for example. Now, the police is trained differently. If there is a law and order problem in a particular area, the police may resort to lathi charge. The police may resort to water cannons. The police may resort to pepper bullets. The police may resort to pellet guns. The police may resort to aerial firing. The police may resort to, let's say, shooting as well. But first to shoot on the legs so that you limp and we can arrest you. Not to kill. And the last resort is shoot to kill. The police is trained like this. But what is the role of the army? If there is border security force to manage the borders during the peacetime, and when there is a war, BSF takes a back seat. It's the army which propels further, and then its principal objective is to defeat the enemy, win the war. Its principal objective is shoot to kill. Army is not trained into doing lathi charge or firing rubber bullets or water cannons. Army's predominant mandate is shoot to kill. Now, there is a disturbance in a particular area. The civilian administration has failed to ensure law and order, to put the situation back into normalcy. Then you have to call in the army. When you call in the army, you can't expect army to suddenly change their DNA and start lathi charging. Army will be there to shoot and kill. But how will army enter into such an area without some protection? You need to be protected because you will shoot to kill and some innocents may also die. Either give us special powers or don't call us into these disturbed areas. Let the police and the paramilitary troops take care of the situation. This is where the idea of a disturbed area comes. Who can declare an area as a disturbed area? Prerequisite of imposing AFSPA in a particular area is that this area should first be declared as disturbed. Because if it's a disturbed area and then the army is brought into it, army will have the special power of ensuring law and order in this disturbed area. Who has the power to declare an area as disturbed? This can be an important question for your exam. This power is given to the central government. This power is given to the state government as well. This power can be given to an administrator of a union territory as well. So who has the power to declare a particular area as disturbed area? This power is given to the central government. This power is given to the state government as well, which means the governor of that state. This power is given to the administrator of that union territory as well. And once this area has been declared as a disturbed area, Armed Forces Special Powers Act applies. There are a couple of important judgments on this. In Inderjeet Barua versus State of Assam, 1983, Supreme Court said, yes, governor of the state has the power to declare an area as disturbed area, but it can't be arbitrary. It has to be with some logic. For example, if AFSPA is imposed in Manipur, it is with logic. It is not arbitrary because there is chaos in Manipur. But at the same time, second important judgment, Naga People's Movement of Human Rights versus Union of India, 1998. The court has said that disturbed area cannot be declared as a disturbed area for an indefinite period of time. You have to periodically review the condition of this area. That too, before the expiry of 6 months. Periodic review is to be conducted. So once you declare an area as a disturbed area, you can't do it forever. You can't do it for an indefinite period of time. You have to review the situation of that area every 6 months and then ascertain whether it should continue as a disturbed area or not. And once it is disturbed area, Armed Forces Special Powers Act comes into the picture. And what is this Armed Forces Special Powers Act? Special powers given to the army. What is that special power? I am part of the armed forces. I enter a disturbed area. I see there is some disturbance. I will shoot. And I will shoot even to kill somebody on mere suspicion as well. Because if I am part of the armed forces, I see some disturbance, I will not go in and go out and check whether you are terrorists or you are miscreants or you are innocents. I have to ensure law and order. I may shoot you as well. Even if I am suspecting you of something, on mere suspicion, I can kill you. I will give warning, but the kind of warning that I consider necessary. So power is given to the army. You decide the kind of warning that you can give. I can arrest somebody without warrant as well. I see there is disturbance in a particular area. I see that in this particular house, there may be terrorists stationed. Should I first go to a judge, wake him up and tell him that you give me the arrest warrant or search warrant, then I can search this premise, then I can arrest these individuals? No, I can arrest without an arrest warrant. I can search this premise without any search warrant. These are the powers available with Army when Armed Forces Special Powers Act is in place. You have a fundamental right that if you are arrested today, within 24 hours of your arrest, you have to be produced before the nearest magistrate, so that the nearest magistrate can decide whether you should be sent to a judicial custody or you should be sent to a police custody. But if in a disturbed area, army arrests somebody, then this arrested person is to be produced before the nearest police station. When? With the least possible delay. Although there are human rights activists and organizations which are criticizing AFSPA for this because army, according to them, is arresting people and not producing them before the police, torturing them. And then when the army is asked, why are you not producing these individuals before the nearest police station? They say under the act, we have the power to hand over them with the least possible delay. So this least possible delay is also not quantified, which means it is liable to be misused as well. And that's the allegation of the human rights organizations. Whether true or not, I don't know. So these are the powers that are available to army when AFSPA is in force. And then there is protection as well. What if I, as the member of the armed forces, I am alleged to have misused these powers and committed crimes, can you file an FIR against me? Can you file a case against me? Can the court pronounce me guilty? No, unless and until there is a prior permission sanctioned by the central government. And the central government is the Defense Ministry. So without central government, without Defense Ministry's approval, sanction, no FIR, no prosecution, no legal proceeding can take place against the army when they are managing the situation under a disturbed area where Armed Forces Special Powers Act is in force. And that's how this year the Supreme Court dismissed the FIR, which was filed in Nagaland against some 30-odd army personnel who were accused, who were allegedly involved in killing some Naga tribes in Nagaland a couple of years ago. Why? Because no prior sanction of the Defense Ministry was given. Unless and until Defense Ministry gives the permission, there can be no legal proceeding against army personnel when it comes to areas which are disturbed under the Disturbed Areas Act. Clear? Okay, so topic number 5 is done. Let's look at topic number 6, the consensus document. And this article is written by C. Rajkumar in the Indian Express. What is the context here? If you look at November 26. On this date in 1949, the Constitution was adopted. January 26. On this date, the Constitution came into force. And that's how we celebrate it as the Republic Day. November 26 is celebrated as the Constitution Day. January 26 is the Republic Day. But November 26 is celebrated as the Constitution Day since when? Tell me in the comment section, since when? (1949). No. Since 2015, because in 2015, the central government issued a notification and said from now onwards, November 26, this is the date on which the Constitution was adopted, will be celebrated as the Constitution Day. Previously, this day used to be celebrated as the National Law Day. 2015 was also the year of the 125th birth anniversary of Dr. B.R. Ambedkar, the chairman of the drafting committee, the architect of our Constitution. And November 26, which means yesterday, was celebrated as the Constitution Day. C. Rajkumar argues, what should be the inspiration that the current parliamentarians should embrace from those who were part of the Constituent Assembly which drafted the Constitution of India? Because all those who were part of the Constituent Assembly which drafted India's Constitution, they were not from a homogeneous party. Even those who belonged to Congress, they had different viewpoints. Even those who were from a particular state, they had a different viewpoint. So this was the group of people who, regardless of their political affiliation, they debated, dissected, enjoyed the proceedings of the Constituent Assembly and thoroughly debated every section of the Constitution. And that's how we have the Constitution, which Mr. C. Rajkumar says is a consensus document. After all, there was a consensus in the Constituent Assembly. Yes, there was voting as well, but broadly there was consensus. And that Constituent Assembly, through consensus, despite the fact that there were members belonging to different ideologies, political, religious, social ideologies, yet they were able to come together, produce this beautiful consensus document called the Constitution. And how should today's parliamentarians learn from those who were part of the Constituent Assembly? That's the focus of this column. C. Rajkumar writes, the most important lesson to learn from these Constituent Assembly debates is how people can vehemently and respectfully disagree with each other without questioning motivations. I disagree with you, but I am disagreeing with you, but I'm not attributing motives to you. I am not questioning your values or your commitments to the nation. So they vehemently disagreed with each other, but that too in a civil manner, through debate, which is the hallmark and bedrock of democracy of any country. That's something that our current parliamentarians should learn from. In fact, this is the quote from Dr. B.R. Ambedkar, the architect of our constitution, the chairman of the drafting committee. He says, fortunately, there were rebels in the Constituent Assembly. They were Mr. Kamath, Dr. P.S. Deshmukh, Mr. Sidhwa, Professor K.T. Shah, Professor Hriday Nath Kundru. The points they raised were mostly ideological. These are the writings of Dr. Ambedkar. That I was not prepared to accept their suggestions, that does not mean that there is no value to these arguments, to their suggestions. The fact that I have not accepted their suggestions, that does not lessen the service they have rendered to the Constituent Assembly. And through their suggestions, through their debates, through their criticism, they have enlivened the proceedings of the Constituent Assembly. That is the substance that our current parliamentarians should embrace. How you can disagree with each other without calling each other without calling names, without attributing motives, without questioning your commitment to the nation, without questioning your values. And then Mr. C. Rajkumar, he presents some data. What is that data? Let's say this is before 1990, and this is after 1990. Before 1990, if we look at the number of days, if we look at the number of hours that every parliamentary, every Lok Sabha had participated in, if we can change the color. Before 1990, Parliament would meet for 550 days. After 1990, this number reduced to 345. But sir, how can you say 550 days? There are 365 days only in a year. I'm talking about the 5-year term of the Lok Sabha. In the entire 5-year term of the Lok Sabha, Parliament would meet for 550 days before 1990. And after 1990, this number reduced to 345. So there has been declining role of Parliament. Parliament's impact has been reduced. If you look at and convert it into number of hours, it used to be 3,500 hours before 1990. And after 1990, this number has been reduced to 1,800 hours. That means the quality of debates, the quality of discussions, it has reduced. Not just that, if we change percentage of all bills, how many bills were referred to parliamentary committees? That is the question that we frequently have been asking. That the job of the parliament is to make laws. And how can we make effective, better laws? For that, there should be thorough debate, discussion on the provisions of that law. And it is better left to a committee of the parliament. Let that committee of the parliament study that bill in detail come up with reports, come up with suggestions, come up with modifications. And in fact, the members of the parliamentary committees, it is argued, it is hoped that they will rise above their party mandate. They will rise above their party affiliations and will talk about the nation as a whole rather than their party interests. So most of the bills should be referred, most of the critical bills should be referred to parliamentary committees. But the percentage of bills being referred to committees of the parliament in the 17th Lok Sabha, this percentage is just 16. 16% of all the bills were referred to parliamentary committees. Not just that, if we look at another statistic, if this is 15th Lok Sabha and this is 17th Lok Sabha, in the 15th Lok Sabha, 36% of the bills. In the 17th Lok Sabha, 35% of the bills were passed. And the debate around these bills, debate lasted less than 1 hour. So look at the declining significance of the parliament as an institution. Not just that, if you look at another statistic, average time spent on debating union budget or passing union budget before 1990, it used to be 120 hours would be spent on debating and then passing the union budget. And after 1990, this number has been reduced to 35 years, 35 hours. And in fact, in 2013, in 2018, I guess also, in 2023 as well, union budget was passed without discussion, without any debate. So this is what Mr. C. Rajkumar argues, that on this Constitution Day celebrated on the November 26th, what are the lessons from the Constituent Assembly for today's parliamentarians? How we can disagree with each other, yet be civil, without questioning your motives, your commitments to the nation, your values. How the variety, the dissent that we see in the Constituent Assembly, it basically added to the charm of the Constituent Assembly, according to Dr. Ambedkar. And there will be dissent, there will be disagreement, there will be different voices, dissenting voices in the parliament as well. But that should not be, those noises should not be drowned under this symbol of nationalism or anti-nationalism. Listen to each other, respect each other's viewpoints, debate. More and more bills should be referred to the select committees. Let the number of sittings increase. Let the number of hours that parliament functions increases. Let more and more bills should be passed with more debate. The debate should last for hours. And how we can also enhance the amount of time that we spent on passing the budget at least. If you would notice that the quality of debates in the parliament has been reduced, and a bulk of that reason has been thrust upon the anti-defection law, because in anti-defection law, you have to toe the line of the party. That is why some people argue that anti-defection law should be junked, should be abrogated, so that individual parliamentarians can, without whip, discuss anything inside the parliament and vote in whichever way they want to vote. They can even take a line which is not part of their party's line on important issues. In fact, this was the question which was asked, I think, in 2013 mains exam as well. The role of individual MPs has diminished over the years, and as a result, healthy, constructive debates on policy issues are not usually witnessed. How far can this be attributed to the anti-defection law, which was legislated with a different intention? 200 words, 10 marks. This is in 2013. That completes our topic. In how many states or UTs AFSPA is in force? AFSPA was in force in almost the entire Northeast at one point in time. It was also in force in Punjab and Chandigarh when there was the Khalistani movement. As of now, it is in force in the entire Jammu and Kashmir. It is in force in Nagaland. It is in force in the 4 districts of Assam. It is now in force in Manipur as well. It is in force in Arunachal Pradesh as well. It was in force in Tripura, but then it was revoked in Tripura in 2015. It was revoked from Mizoram in 1980s. It was revoked from Meghalaya in 2018. In fact, it was revoked from Manipur as well, but now has been reimposed in the violence-hit districts of Manipur. Okay, great. Let's come to topic number 7, the Sambhal violence. And before we proceed with this discussion, do like this video if you are understanding these topics. The district court in Sambhal, which is in western Uttar Pradesh, ordered the inspection of Shahi Eidgah Mosque in Sambhal. The petitioners had argued that this Shahi Jama Masjid, it was built over a site which was once a Hindu temple. And then the district court, it gave the permission for the inspection. The first inspection was done. The second inspection led to violence, which led to the deaths of 4, injured others as well. But the larger issue that the Sambhal violence raises is on the Places of Worship Act 1991. The year was 1991 when this Places of Worship Act was passed by the Indian Parliament. The then Home Minister, when he introduced this bill in the Parliament, he said, what is the objective of this law? The objective is that once this bill is passed, it will go a long way in restoring the communal amity and goodwill in India. What was the purpose of this law? If there is a religious structure, what was the character of this religious structure on the 15th of August 1947? That character needs to be maintained, and this character cannot be converted at any cost. What does that mean? If this is a religious structure, and on 15th of August 1947, it was a Hindu temple. After that, it cannot be converted into a Muslim shrine. This act says we have to preserve, maintain the religious character of this institution. Whatever the character of this institution was on the 15th of August 1947, that character will have to be maintained, and you can't convert the character of that religious institution. Character in the sense, if it was a mosque on 15th of August 1947, you have to maintain its character. Later on, you cannot change it into a temple. Again, listen to me carefully. If it was a mosque belonging to Shias on 15th of August 1947, after that, you cannot convert it into the mosque for Sunnis as well. Sunnis. Which means whatever the character was, whether character of a particular religion or any sect of that religion, you have to maintain that character. You can't convert it. But when this law was passed in 1991, the Ayodhya Ram Jannabhoomi site. It was kept out of it. Why? Because that matter was already pending before the court. Because the matter was sub judice. That is why Ayodhya Ram Janmabhoomi Temple, this site was kept out of the Places of Worship Act 1991. And in fact, this act was quoted in the Ayodhya judgment as well. In Ayodhya judgment, which was a 5-judge bench of the Supreme Court in 2019, ruled that this 2.77 acres of land, disputed land at Ayodhya, it belongs to Ram Lalla Virajman. The petitioner in that case was Ram Lalla. And in that case, the Supreme Court said, we cannot use courts to undo the wrongs committed in history. So Places of Worship Act 1991, it lays down the secular identity of India. And secularism, again, as I said, is part of the basic structure of the Constitution. But similar things we witness. For example, what is the issue in Sambhal? Shahi Jama Masjid, allegation is that it was constructed at a site which was previously a Hindu temple. Same is the petition at Gyan Vyapi in Varanasi. Same is the case at the Shahi Eidgah Mosque in Mathura. Same is the case in different parts of the country, where the allegation is that a temple was destroyed and then a mosque was constructed. But if the Act of 1991 says, whatever was the religious character of an institute on 15th of August 1947, you have to preserve that, you have to maintain that, you cannot convert it. When Gyan Vyapi issue came up before the court, Justice Chandrachud was the judge. Justice Chandrachud said, yes, you cannot change the character of a religious institution, of a religious place of worship, as it stood on 15th of August 1947. But this Act of 1991 does not bar the ascertainment, which means there can be surveys. Sir, what is this confusing topic? Listen to me carefully. Gyan Vyapi, Shahi Eidgah at Mathura, or this masjid at Sambhal. There is this Places of Worship Act 1991 saying that if these were mosques on 15th of August 1947, after that you cannot convert them into temples or any other place of worship. Clear? But this 1991 law, it does not prohibit from inquiring what was the character of this institute previously. And what was the character of that institute previously? For that we will inspect it. For that maybe archaeological survey will be conducted to ascertain what was the character, original character of this place. But even if the character of this place is found out to be a Hindu temple, but the 1991 law prohibits the conversion of that place into a place of worship of a different institution. So the central piece to this violence at Sambhal is this Places of Worship Act. But even this Places of Worship Act has been challenged in the court. On what grounds? Ground number one, this date, 15th of August 1947, you have arbitrarily chosen this date. Why 15th of August 1947? Why not some other date? The petitioners argued that even before the independence of India, hundreds and thousands of temples belonging to even Jains or Buddhists, those temples have been destroyed and mosques have been constructed on those ruins of those temples. So by fixing this date, 15th of August 1947, you are arbitrarily denying justice to those communities, which in fact affects their fundamental right under Article 25. Freedom to profess, practice and propagate your religion. And if you have the fundamental right to practice your religion, how can your faith be compromised? When your faith tells you that that particular place was the place where a temple was originally established or put up. So Article 25 is getting violated. You are arbitrarily putting this date, according to the petitioners, and as well as you are violating the basic structure of the constitution, which is judicial review. Because places of worship says all other cases apart from Ram Janmabhoomi, Ayodhya, Babri Masjid case, all other cases, if they have been filed, those cases will lapse. No further case can be filed. The petitioners argued that you are violating another basic structure of the constitution, which is judicial review. So what can happen in this situation? Either Parliament tomorrow will pass a law, will repeal this Places of Worship Act 1991, or only through consensus, through Hindu-Muslim dialogue, can such cases be resolved. We should not go to the courts to find solutions to the problems, because the court will only look it into a civil case, civil dispute, saying who is the owner of this property. Nothing more, nothing less. It is only through Hindu-Muslim dialogue, it is only through participation of the civil society of the two religious communities to solve these problems, because it should not lead to violence, it should not lead to further tearing apart the social fabric of India. So what is happening in Sambhal? The district court asked inspection of that particular mosque to ascertain whether the place previously was a Hindu temple or not. This is similar to Gyanvyapi, this is similar to Shahi Eidgah Masjid in Mathura, this is similar to some other cases as well. Central to this is the Places of Worship Act 1991, which basically says that the character of a religious property, the place of worship as it stood on 15th of August 1947, that character needs to be maintained, and it prohibits the conversion of that places of worship. But then why are these surveys being ordered by the court if you can't change the character of that institution, character of that places of worship? Because Justice Chandrachud in one of his judgments said, although the law of 1991 prohibits the conversion of the place of worship, but it does not prohibit ascertaining what was the original character of this place of worship prior to 15th of August 1947. Which basically means that if tomorrow you establish that that particular place of worship, which today belongs to Muslims, previously was belonging to the Hindus, then should you not then convert it as well? If you don't convert it, you are violating Article 25 of the petitioners. If the court says we will not further deal with this matter, you are violating judicial review, which is part of the basic structure. So for that, the solution can be either this Places of Worship Act will be repealed by the Parliament, or there should be the dialogue, the community level dialogue, the cross-cultural dialogue between different religious communities to solve problems. Because let's not leave it to the political class, let's not leave it to the judiciary as well. Let the intelligentsia, civil society together decide how to resolve these problems, which have the potential of tearing apart our social fabric. Clear? Okay. Last topic, topic number 8, Municipal Corporations tax revenue share rise in recent years. 74th Constitutional Amendment Act. What it did? It gave constitutional status to whom? Urban local bodies. Municipal corporations, municipalities. But the idea is that these urban local bodies should be given so much power that we enable them to function as urban local self-government. That means they should be able to sustain themselves. manage themselves on their own. They should not be dependent upon the state or the center for funds. This is where one of the problem lies, and the problem is with 3 Fs. What are the 3 Fs? Problem of funds, problem of functions, problem of functionaries. Funds in the sense, urban local bodies are dependent upon state government for funds, dependent upon the Union Finance Commission for funds. They are unable to generate their own revenue, except some, but broadly they are unable to generate their own funds. If they are unable to generate their own funds, which means they can never become self-governing institutions. Second is functions. Because if you look at the 74th Amendment, which talks about 12th schedule of the Constitution, it talks about 18 items, 18 functional items that can be given to the municipalities, that can be given to urban local bodies. But the Constitution uses the term, the state legislature may transfer these 18 powers, 18 functions to urban local bodies. Ideally, it should have been the state legislature shall, the state government shall transfer these 18 functional items to urban local bodies. And the third problem is with the functionaries. Municipal Corporation is headed by a commissioner who is a senior IAS officer appointed by the state government, basically responsible to the state government. Similarly, in a municipality, the chief executive officer is a senior state civil servant appointed by the state government. And these functionaries, they don't listen to these elected councillors. So the problem, and these urban local bodies are unable to recruit their own staff. So the problem is with the funds, problem with the functions, problem with the functionaries as well. And in fact, CAG conducted a performance audit of urban local bodies in UP between the term 2015 to 2020. And CAG performance report says that out of these 18 items, only one is fully devolved to the urban local bodies. And what is that one function? Construction, maintenance and operation of crematoriums and burial grounds. This is the only function which has been fully devolved to urban local bodies in UP. All other functions are controlled by the state, are not fully devolved to the urban local bodies. And the CAG report also said that close to 16% of the revenue is generated by these urban local bodies in UP from their own revenue, from their own funds. Because urban local bodies, they have the power to impose property tax, water tax, other fees. They can charge user fees as well. This is something that you would know. So only 16% of their revenue is generated by their own funds. The rest is being contributed by the state government or by the central government, which means they will never become self-governing urban local governing institutions, self-governing institutions. But now there is a report. What is that report? This is the second time this report has been published. This is the report by the Reserve Bank of India. Keep note of it, can be asked in your prelims examination. What is this report? The report on municipal finances. What was the theme? Own sources of revenue generation in municipal corporations, opportunities and challenges. This data point, if you use in your answers, it will lend weight to your answers, credibility to your answers. What this data point is telling you, I'll summarize it for you. When it comes to states such as Karnataka, Telangana, Tamil Nadu, close to 50% of their revenue they're able to generate from their own funds, in a sense through imposing taxes, through charging users for the fee, by charging user fee for the services that they provide. For example, they are providing services such as, they impose tax such as property tax, water tax, electricity tax, education tax. Through all these things, they are able to generate revenue, funds for their own institutions. And this is where the southern states, Karnataka, Telangana, Tamil Nadu, corporations in the southern states, they are on top of the list in terms of own tax revenue generation. They are able to generate own tax revenue and not entirely dependent upon the state and central government for funds. So over a period of time, they will become units of local self-government, urban local self-governing institutions. And on the bottom, we have states such as Tripura, Sikkim. Amongst the bigger states, we have the UP, the Bihar, the West Bengal, which are performing poorly. But the southern states, and surprisingly, Jharkhand is also performing better in having more own tax revenue generation capacities and capabilities. These data points you can use by citing this report of the Reserve Bank of India, and that brings us to the closure of this session. Okay? That's about it for today. If you have got the benefit from these topics, please let me know in the comment section. And if you want that we should continue these UCAN sessions on YouTube and not on Unacademy platform, do let me know in the comment section as well. And subscribe to our channel if you haven't yet. See you again next time. Till then, have a great time. All the best. Bye-bye. Good night.